They asserted that their conduct did not fall within the scope of paragraph 21A of the 10th schedule. The Speaker, however, disqualified the MLAs under paragraph 21A of the 10th schedule. The Speaker's decision was challenged before the divisional bench of Karnataka High Court. The division bench, comprising of Honorable Chief Justice and Justice N. Kumar, gave differing judgments. The Honorable Chief Justice rejected all the contentions of the MLAs and dismissed the writ petitions, while Justice N. Kumar, in his separate judgment, differed with the views of the Honorable Chief Justice in regards to interpretation of paragraph 21A of the 10th schedule and set aside the Speaker's order. The matter was then referred to a third judge, who in turn concurred with the judgment of the Honorable Chief Justice. Thus, by a majority, it was held that Speaker had rightly disqualified BJP MLAs. The order of the Speaker and the judgment of the High Court was challenged before the Honorable Supreme Court. In its judgment, the Honorable Supreme Court extensively referred to with approval the observations made by the dissenting judge of the Karnataka High Court, Justice N. Kumar. I am in complete agreement with this view and am bound by it. I reproduce the said paragraph which are relevant for the present purpose. Justice N. Kumar, who along with the Chief Justice heard writ petitions filed by the appellant herein, in his separate judgment, differed with the views expressed by the Chief Justice in regards to the interpretation of paragraph 21A of the 10th schedule of the Constitution. The learned judge went on to further hold that when a member of a house expressed his no confidence in the leader of a legislative party, and if he happened to be the Chief Minister who is heading the Council of Ministers and had written to the Governor in that regard, such act by itself would not amount to an act of floor crossing. Similarly, if the Governor, after taking note of the expression of no confidence, was satisfied that the Chief Minister had lost majority support in the House, he could call upon the Chief Minister to prove his majority on the floor of the House. It was further observed that if the Chief Minister, on such request, failed to establish that he enjoyed the support of the majority of the members, the ministry would fall. But such an act of the member of the House would not constitute defection under 10th schedule. By such an act, the political party which had formed the government would not lose its right to form a government again. On the other hand, what is disturbed by such an act is the government of the political party with a particular leader in whom the members of the House belonging to the same political party have no confidence. But this would not mean that the member of the political party to which the Chief Minister belonged had given up his membership to the political party. Having dealt with the various decisions referred to here and above, the learned judge came to the conclusion that it was clear that an act of no confidence in the leader of the legislative party does not amount to his voluntarily giving up membership of the political party. Similarly, his act of expressing no confidence in the government formed by the party with a particular leader as the Chief Minister would not also amount to a voluntary act of giving up the membership of that political party. The learned judge further observed that deserting the leader and deserting the government is not synonymous with deserting the party. If a member resigned from the ministry, it would not amount to defection. What constitutes defection under paragraph 21A of the 10th schedule is deserting the party. The learned judge observed that dissent is not defection, and the 10th schedule, while recognizing dissent, prohibits defection. In this background, on an appreciation of facts on record, I find that the present petition do not attract or justify actions under the 10th schedule. In my view, the petitioner cannot and should not use the provisions of 10th schedule as a weapon to silence or browbeat the members or to crush opposition. That would be a complete abuse of the process of law and would run counter to the constitutional intent behind the 10th schedule. It also underlines the instance of the Election Commission of India to bring about changes in the party constitution to make it more democratic by providing party cadre a platform to express themselves and give them a voice in the party's decision making. It may be that some members go overboard and make some statements or do some acts which may be in breach of party discipline. It would be for the political party to deal with them appropriately and not for the 10th schedule. Looking at the degree or gravity of the indiscipline, the concerned members may be censured, admonished, or reprimanded or given a more extreme punishment such as suspension or expulsion from the party, as may be warranted by the party's rules. Even the most extreme punishment of expulsion from the party would not have the effect of these members losing their seat in the House.